Good afternoon. Thank you for joining us today in a discussion about enforcing your rights under Lien Law 182. My name is Eric Airy. I'm Executive Director for the New York Self-Storage Association. I will be monitoring questions submitted by today's attendees. We are recording today's event and we'll have it posted on the New York Self-Storage Association website this week. We have with us today Adam Steckler, President, Third Party Management of Storage Mart, Joseph Miller, Partner at Miller & Lee LLP, and Peter Ferraro, CEO of the NYSSA. All participants have been muted upon entry. We ask that you please stay muted throughout the entire presentation. The attendee control bar can be found at the bottom of your screen. Here you can adjust your audio settings and connect through your computer's audio, a headset, or connected speakers. This is also where you will participate in the Q&A by sending your questions in throughout the presentation. We will keep identities anonymous. In the upper right-hand corner of your screen, you can adjust your video settings to view the webinar in full screen mode and adjust your view to see the speaker versus all panelists at once. We would like to thank our corporate partners, Extra Space, Life Storage, Public Storage, and Storage Mart for making events like this possible through their support. We will follow with a Q&A session as time permits. At this time, I'll hand it over to our moderator, Adam Steckler.
All right, thank you everyone for joining us this afternoon. We've got a great webinar on enforcing your rights under Lien Law 182. I know that's a topic a lot of people are very interested in. My name is Adam Steckler. As Eric said, I'm President of Third Party Management at Storage Mart. Storage Mart's the largest privately owned and operated storage company in the United States. We have 210,000 units across 280 locations. In particular, we also own Manhattan Mini Storage, which 56,000 units in New York City. And I'm going to let my good friend Peter Ferraro introduce himself now.
Good afternoon. My name is Pete Ferraro. I'm the CEO of the New York State Self-Storage Association. I've been with the association now for over 20 years, and I've been in the business for over 30 years. And today's webinar, we have the finest talent in regard to self-storage. We have Adam Steckler, and we have with us also Mr. Joseph Miller. Joseph Miller.
Hi, Peter. Hi, everybody. Yeah, I'm Joseph Miller. I'm with the law firm of Miller & Lee. I'm a founding partner. We focus probably 60 to 70% of our practice on representing self-storage companies. I've been representing self-storage companies for over 20 years. We represent the largest self-storage company in the world. If you include the holdings in Europe, we represent companies from one facility all the way up to thousands of facilities. We've dealt with every issue you could possibly think of. And hopefully today we'll be able to answer as many questions and give as best the information as we can.
Okay, great. I'm going to do a quick disclaimer about legal advice, and I'm going to read through this disclaimer. The New York Self-Storage Association, NYSSA, nonprofit trade association, is a nonprofit trade association and does not provide legal services to its members. The information on this webinar has been prepared and published for informational purposes only. It is not designed to be and should not be used as the sole source of information when analyzing and resolving a legal problem or deciding on the content of any document to be used in your business. None of this information is offered nor should be construed as legal advice. You should not act or rely upon information contained in this webinar without specifically seeking professional legal advice. So now that we have that out of the way, let's talk about what we're going to do today. So Joe is going to talk to us and really be our subject matter expert on Lien Law 182 and what the law permits and what language is in that lien law section. And Peter and myself are going to talk about the business side of it. There are operational decisions, business decisions that the lien law itself is subject to interpretation. There may be different ways of how you apply it in your business. So I'm going to give some examples of how we interpret it at Storage Mart, and Peter will give some experiences from his experience. And Peter, you want to talk about auction as a last resort?
Yes, what I would just like to mention that before we get into this, the position should always be that the best auction is no auction. You should do everything in your power to try to get in contact with your tenant to resolve any issues. If you cannot resolve an issue or cannot get into or cannot contact your tenant, then we're going to go through the procedure today on how to follow proper protocol. Once again, the best auction is no auction. Thank you, Adam.
And we'll talk more about that as we go through. So what's the agenda for today? So we're going to walk through this process, these 5 major steps. We've sort of separated it for the purposes of the conversation. So rent's due on a specific date. And when the customer does not pay, it kicks off this process. So we're going to go through the overlock, the lock cut, the notice of sale, the advertising for the auction, and sort of get into the auction process itself and what does it mean when the auction is complete. So those are the 5 big steps we'll go through. As you have questions, like Eric said before, please hit the Q&A button, submit your questions. As I see them pop up, I'm going to try to address them as we go along in each of the different sections. So let's start off with the overlock, physical and electronic. Why don't we start here? What is overlock? When can I overlock? Should it be in the lease agreement? I'm going to let Joe kick things off here.
Okay, I'm gonna make the statement that I give at basically every seminar and every lecture I give. Lien Law 182 is a limited statute. In many respects, it doesn't give you guidance on what you actually need to do. You have to look to other statutes. And you always have to remember that Lien Law 182 has to be read in conjunction with other governing statutes. And one of the biggest things that I always tell my clients is, if you're going to overlock a unit, it's more than just putting an overlock on it and then putting your security code on it. It's making sure that you actually have the right to overlock the unit, and you're not going to end up in civil court on an LT matter for a wrongful eviction. And what I say by that is there's a case, McIntosh, it's a very extensive decision from the civil court. McIntosh, by the name of John McIntosh, the name is going to sound familiar to a lot of people. McIntosh first, I believe it was Storage Post, and I'm sorry, by Prime Storage, McIntosh first Prime Storage. And what the judge did in great detail is she said the reasons why we were allowed to overlock it. And she said the reasons why you were allowed to overlock it is because your lease gave you that right to overlock the unit. So if you don't have in your lease that you're going to overlock the unit, you should put it in your lease, because if you don't have it in your lease, you have to fall back on arguing the Lien Law 182 says I have the right to sell the property, then obviously I have the right to bar them from accessing the unit. I don't necessarily agree with that logic, but although I have to make it. So the first thing you do is, does my lease say what's going to happen in the event you don't pay? And it should say, I will overlock your unit, I will bar you access, I will disengage your access code if you use access codes. Now, I'll let Adam and Peter talk about what's the actual mechanics of overlocking a unit, but I can't emphasize more. Make sure your lease agreement says to them, I will overlock your unit and bar you access, or you're running down a road you don't want to go to. Adam, you want to talk about the physical overlocking?
Yeah, so just to give you an example of what we do, and this is just one operational example. So all the examples I'm going to go through today, I'm going to assume a September 1st payment was due date. And so 4 days after the past due date, September 4th in this case, just an example, we disable, building access is disabled. So our customers have an access card, and that card is turned off. So there's initial step there. 10 days after it's past due, the room is physically overlocked. So we go to the room and there's a second lock that's put on the room, a cylinder lock that we lock. And there can be additional charges associated with this as well. Peter, is this consistent with your experience, or you guys do it a little differently?
Well, actually, everyone can depends on what their business model and what their business policy is. You can, whatever you do, whatever you decide to do should be specific in the lease agreement. So if you plan on overlocking after 5 days, and I'm just going to use 5 days as an example, but I think the example should be reasonable. You don't want to overlock the room if the rent is due on the 1st and on the 2nd day you overlock the room. I would think that would be unreasonable. So you choose how you want to manage your facility. So if it says in your lease agreement that after a certain amount of days, you can overlock the room, or electronically, if you have the gate access, you can lock them out of the facility. Also, should there be any fees associated with that, it should be very explicit in your lease agreement.
Just to jump in there, Adam, again, there's nothing in Lien Law 182 which says when you can overlock. I tell my clients, and everybody knows I'm very aggressive with enforcing the lien sale. I tell them on day 6, if it's due on day 6, and that's when you're going to put your late fee into, then overlock on day 6. You don't have to agree with me, but I'm telling you, you can do it. I typically suggest, don't overlock before then. But again, there's ambiguity in the statute. It doesn't say when. I mean, I typically tell people, if you want to look at some of the amendments that were made to the RPAPL in 2019, for guidance, then it's day 6, you start overlocking the unit. But again, there's nothing which says, when you can do it. As far as giving the dates when you do it, I don't go that specific as to on day 6. I don't say in your lease on day 6, I'm going to overlock the unit. I just say, if you default in payment, this is what's going to occur. I think it becomes dangerous to give such a specific day, because God forbid your 18-year-old standing behind the counter forgets to do it or does it sooner. Then you run into problems. But as Pete is correct, that the statute requires that you set forth all fees which are mandatory in it. So you have to tell them what the fee is going to be. So if there's an overlock fee, you have to tell them what the overlock fee is, and the statute requires you tell them whether it's mandatory or optional.
And Joseph, the other thing is that whatever your business model is, it should be reasonable and consistent. So every month and every customer should march at the same beat.
Absolutely.
Okay, good advice on that. So moving to the next step, which I have a lock cut here. And some people may think this is early in the process or it should be later, but we'll get into why we have it at this step number 2, lock cut. So I have a bunch of questions here. Should I do it? When do you do it? Where should we start, Joe?
Well, okay, there's 2 schools of thought here. There's 2 practices that I've encountered. 1, you do cut it and you do a quick inventory, or 2, you don't cut the lock until you're pulling the unit up for the sale. And then there's actually a third, which has come up with when people are doing online auctions. And then by necessity, they have to, at some point, cut the lock, take pictures. If you read Lien Law 182 and give it a strict interpretation, you have to, at some point, cut the lock to do an inventory, because if you don't do that, there's no way you're going to be able to put in your lien sale letter a description of the contents of the unit. Now, the reason why this gets so troublesome is because our statute is based upon a statute which was governing warehouses. It was literally, the language almost mirrors the predecessor UCC Article 7. And the reason why it's troublesome for us is a warehouse, they're inventorying the property when they take it in and they have possession over it. It's a bail-or-bailey relationship. In Lien Law 182 or self-storage, it's not a bail-or-bailey relationship, and we never take possession of it. So we don't actually know what's in there. So if you simply read the statute the way it's written, by necessity, you're going to have to cut the unit at some point and do a quick inventory in order to give a proper description. Now, the competing way of doing that is that you simply write into your lien sale letter for the description, and I'm going to read it straight from the case which we all refer to, and then I'm going to caution everybody about relying upon this case as the end all and be all. It simply says your property in the unit. That's literally the description, and that comes from a case you've heard me say because it's your case. It's Goldberg versus Manhattan Mini Storage Corp. And literally the court said the description of, and here's the description, the property stored by you, close quotes, was the description. They said that was sufficient. So if you're going to work on the rationale that I'm not cutting the lock until the sale itself, that's what you should be putting into your language similar to that should go into your agreement, and then rely upon that. Now, reason why I caution you is because that case is from a court of very limited jurisdiction. It's from a lower appellate court case. There's no other cases dealing with this issue. So you have those 2 options. And then the third one, like I said, that's popping up is you're cutting the unit at some point to do the pictures. And everybody tells me they do it at different times. Some do it 50 days in advance, some do it 3 weeks in advance. I haven't really grasped, the different companies that do it that way. That actually poses, issues for me, because if you do an interpretation of the statute, you're not cutting it to do an inventory. You're cutting it to take the pictures, and then you lose the argument that, well, I cut it to the inventory to send my letter. So that's a little bit of, that can, down the line, is going to create some type of problems. But, if you ask me, should I cut it? By necessity, you have to cut it.
Yeah, I agree, and we'll get into that more when we talk about the notice of sale letter,
Yeah.
right? To take an inventory of the contents you need to see in it. We take pictures because we do online auctions. We secure the room at the end with a seal. And we take, we record the seal number that we put on it, in case the customer says somebody else went in after that, because their lock's been removed at that point, obviously. Should I videotape the process? Do you think that's necessary? I've heard different people do different things here.
I'm a big proponent of it, because when you get sued, if you're able to say, well, look, this is everything. Nobody went in there and took anything out. We know exactly what's in there. We closed it. You can see us putting the little yellow seal or blue seal, whatever type of seal you use, on it. So I am a big proponent of that.
And when you say take inventory of the contents, does that mean when I enter the room, I can move things around, or I should just inventory based on visually what I see?
I suggest you do it. I call it the public storage way. Pull the door up. Don't even pull it all the way up. Stand back, take a quick scan, see what's in there. A couple boxes, some electronics, some TVs, close the unit back up. Don't actually enter it. Put it into your, the description can be very basic, boxes, totes, electronics. That's going to satisfy the statute. Then close it back up. Don't go in there. Don't start looking in the boxes, because you open a hornet's nest. If you go in there and start looking in the boxes, number one, you could break something. And number two, you could open it up and say, oh my God, there's mortgage documents in here. There's deeds in here. Then you got to deal with that whole personal information mess. That's my suggestion.
Okay, and if I open the room and I find it completely empty, should I continue with the process to like a sort of fake auction, or can I take possession of the room back then? What happens when I find that condition?
Becomes a total judgment decision. You can deem the room abandoned if you choose to do it. If you do choose to, I just literally dealt with this morning. If the room's wide open, person hasn't paid for 3 months, you've had no contact with the person, there's nothing in it, I would make a judgment decision, say, I'm deeming this room abandoned, then follow the abandonment procedure. Make sure you send the person a letter saying, we did X, Y, and Z, seems deemed abandoned to us, or seems abandoned to us. If you don't respond within the next 10 days, we're going to deem it abandoned, we're reclaiming the room.
Okay, anything you want to add, Peter, or should we go on to the notice of sale letter?
That's exactly what I would do. The cutting of the lock sooner than later, because if you open the room and you find an automobile or something in there, it gives you time to re-advertise it in the necessary steps. Because if you find something in the room that's not just ordinary household items, you have to proceed in a different fashion.
Okay, so let's talk about that notice of sale letter, and there's quite a bit of content on this page, so we'll kind of go through this in step by step. So the letter itself has a number of components, and I'll show an example of a notice of sale letter after this that we use, just so you get a better feel for it.
Adam, before you get into that, just give us a timeline on when this letter should go out.
Well, so again, this is one of those, I'll just jump to this next slide because you sort of, so we do it 40 days past due. So again, just an operational example, September 1st due date still, we do it 40 days past due. We wait until that second billing cycle to do it. Now we are looking at condensing it, and I believe we're allowed to, but right now as a business decision, we wait longer than we probably need to, but on day 40, about 40 days, we cut the lock. That gives us the information we need to prepare the notice of sale letter. Maybe Joe can address, what we're permitted to do timing wise.
Yeah, again, as far as the statute goes, there's no specific, well, there is, we'll get into the 30 days, but there's no specific thing which says when you can send the lien out. Again, anyone who knows me knows that I'm extremely aggressive with the timeline. So I suggest to my clients, get that lien sale letter out between day 6 and day 10. And as we'll talk later, I have a outside date of 60 days from default to when the sale goes, and that has to do with when you're going to incur more fees. So I'm a big proponent. If you get that letter out between 6 and 10 days, two things are going to happen. One, more people are going to respond and pay the rent. We know that. We just know that by experience. And number two, you're going to have a better chance of capping the amount of rent you're going to lose down the line because you'll keep it under 60 days under my timeline. And there's nothing which says you can't do it within between 6 and 10 days.
So the letter itself has a number of components. I'll just read through these things and then I'll let Joe jump in if there's anything else to clarify. It requires, sometimes people say demand for payment letter, notice of sale letter, but the notice of sale letter requires a demand for payment. It needs to have a date and amounts. The demand payment date has to be at least 30 days from the date the letter is mailed. And it needs to include an itemized statement of the amount due, the consequences of non-payment, the time and place of sale. So the key part here I wanted to people to note is that, you know, when you send the notice of sale letter, you already need to know when the auction is happening. That date, you know, that auction timeline is predetermined, so you should know when it is. And it includes a description of the contents of the room, which is what we talked about by the lock cut technically happens before the notice of sale. And if there's any other persons claiming an interest in goods. Is there anything you want to add to the components of the letter itself, Joe?
No, it's spelled right out, but the big thing here that I want to remind everybody, because this is coming up constantly, if you're doing online sales, your sale is not going to be occurring at your facility. It's going to be occurring online. You need to indicate it's going to be occurring online. When the sale will occur, the sale date is going to be the date that the sale will close. So if the sale is going to be closing on the 2nd of July, the sale date is the 2nd of July, but you have to tell them that the sale is going to occur online. I've seen a couple of recent examples where they've still put at the facility, and technically that's an improper letter.
Okay, and some of the mailing requirements, how should I, you know, we talked about when we send the letter. How should I send the letter? Just regular mail, certified mail? What is the best recommended way to do this?
Well, this is actually an easy one because the statute gives us the 3 ways to do it. I'm just going to literally read from the statute. You can do it by personal delivery, which I quite honestly is a ridiculous thought because it's going to cost you thousands of dollars. You can do it by registered or certified mail to the occupant's last known address, or you can do it by verified mail and electronic mail. I'm really not going to spend a lot of time on the electronic mail component because it's quite onerous, but I always suggest that people send it by certified mail. Now, thanks to the effort of people like Adam and Peter, back in October of 2019, we eliminated the return receipt requirement. So if you send it by certified mail to the last known address, and the last known address is the address that you were given by the occupant, and now he could change it. He could go on his online account and change it. That's the address you send it to. I will strongly suggest that if you also know of another address that he's using, send a copy of it to him at that address also. But by law, you have to send it to the last known address as given to you by the occupant.
Okay, and I think we covered most of the things on here. Certified mail, electronic notices. I guess the latest change to the lien law permitted electronic notices if customers enrolled in that process. So is there anything you want to add about electronic notices?
Sure. Let's, I mean, sort of almost a whole separate section to talk about, but let's start off with number one, there's certain provisions that you have to have in your lease agreement before you can even send it by electronic delivery. And that I'll read from the notice. The occupancy agreement states that the occupant is consented to receive later lien sale notices by electronic mail, and the occupant has provided the occupant's email address in at least two locations within the occupancy agreement. So to start off with, those two have to be in there, and all the lease agreements we've drafted in the past 2 years have them. The second thing is that there was sort of a negotiation done by the Self-Storage Association to get the right to do it by electronic mail. And one of the concessions was it has to be sent 2 ways. It has to be sent by verifiable mail, as defined by the statute, and it has to be sent by electronic mail. So basically, if you're going to send it by email, you also have to send it a second way. And verifiable mail obviously is FedEx, USPS with a tracking receipt, or certified mail or registered mail. So what I tell everybody is, if you're going to send it by certified mail anyway, just send it by certified mail and just send the electronic mail as a courtesy copy. Because if you send an electronic mail, and Adam will get into this more, you need a whole bunch of tracking systems in place to make sure the person received it, opened it, and everything else. So everybody nowadays does a courtesy copy. They send it by electronic mail, but you should take the position that the main way I served it was by certified mail.
And that's what we do now also. We've experimented with some of the tools out there for verifying the electronic notice, and you know, we were concerned how it would hold up, so we just stick with the true and tried method.
And I can tell you that from experience, and obviously I have clients who send it by certified mail. The problem you get is, well, not by certified mail, sorry, by electronic mail. The problem you get often is that it bounces back and you don't pick it up, or you get a message that there's not enough space or room in people's systems. I've actually just saw that where it got bounced because they didn't have enough room. And if you're not monitoring that closely, like if your DTM checklist doesn't specifically say, go in and check it out and make sure this happened, you'll miss it and you'll do a sale and you realize, oh my God, this person didn't even get it. Thankfully, if you sent it certified mail, like you should be, then you can look to see if they got it by certified mail. And the beauty of the certified mail under the statute and the case law is that you just have to send it by certified mail. As draconian as it sounds, they don't have to receive it. You just got to show you did it.
Yeah, and that was a question we just got in. You know, the certified letter was sent, but the tenant did not return the certified receipt. So I can proceed, right?
Well, you don't have to send you don't have to send it with return receipt requested anymore. You just have to send it certified mail to the address, last known address given to them. Now, we had an issue where the person didn't get it, and we had I mean, many times we have the issue the person didn't get it, and we've litigated it. So in a case, Public Storage versus Hayden Guest, the court was very emphatic in saying all the statute requires is they send it certified mail, return certified. At that point, there was return receipt requested, certified mail, return receipt requested. You don't get it, you don't claim it, that's on you. They satisfied the statute.
Okay.
I just want to interject something here. It's not necessarily the sending out of the notice. What's important at this point is that you really want to get in touch with the customer. So you send them out a certified letter, they don't have to accept it. They can say, so I suggest that when you send out a certified letter, you can send it out either return receipt or not. I also send out a certificate of mailing, which just shows that you went to the post office and you mailed it out. Most likely, it would be hard fetched for the occupant to say, well, I didn't get the mail. I can understand that they didn't accept the register. I'm not home, I didn't get it, I didn't sign for it, whatever the case might be. But with a certificate of mailing attached, 2 copies that you send out, because the whole point is you really want to get in touch with them. You want to call them, you want to email them, you want to send them a letter, because you want them to get back to you. You want them to know that their items are going up for auction, and that maybe at some point you can try to negotiate something different.
Yeah, it's really good advice. And Joe, so let's just to take this a little one step further, a little twist on this, a question that came in. So I sent the notice certified mail and it's returned because it's undeliverable. So assuming I've taken your advice and I've used the last address provided on the OA, am I still good to proceed even though it came back undeliverable?
As long as you double check the address and you make sure it's the exact address that they gave you, then yes, under the law, you can proceed.
And again, and it just follows up with Peter's advice that, you know, just because I got that back undeliverable, I should be making phone calls, attempting to reach that customer in other ways so they're aware of what's happening.
Yeah, I mean, I think it goes without saying that I don't know any client who doesn't make at least 6 or 7 phone calls before the lien sale. Every single client I know is calling the day before and many the morning of the sale. I mean, you want to keep making the calls to try and get in touch with them, but there's a reality. And I think, Adam, most of your facility or all your facilities are in the city. 9 times out of 10, you end up calling a number and it doesn't work anymore. And then you're saying, what am I doing? Then you're saying, well, I emailed the person, they didn't respond. So there's only so many things you can do. But yes, you should keep making those phone calls, because when you're at, trust me, when you're at trial and you pull that ledger up, you want to be able to say to the jury, I just didn't send the letter. I tried to contact the person. The morning of the sale, I called them. The morning before the sale, or the night before, I called them. I did everything I can to get in touch. And here's the reality. I have to sell it because it's part of the business. It's the only way we can survive.
Right, so what I'm suggesting is when you send out the letter, notice of sale, what I suggest is everyone should have an application when the customer comes in that he fills out, his name, his address, whatever, social security, whatever the case might be, there's some paperwork that the customer or the potential tenant needs to fill out at the counter. So when we start the process of mailing out or doing what we need to do to contact the customer, we take that initial application that the potential tenant has filled out, and we make sure that the address that he physically put on that piece of paper is the same address that we're mailing to. So that if it does bounce back, and in your lease agreement, it should say that if your tenant, if the tenant moves or changes his address, they have to let us know in writing that they change. So what you really want to do at this point, when you're starting the process, is to build a paper trail so that if something was to happen, so it stops the manager from possibly making a mistake or possibly sending it to the wrong address or doing what you need to do. So at that point, the whole issue is to start a paper trail to make sure everything is going the way it's supposed to go.
Okay.
Adam, one thing that I forgot to mention, our statute has a little weird language. I'll be quite honestly with you. I've always scratched my head. Why do we allow that in there? With respect to the mailing, okay? So we have language that says this. Evidence of mailing is received. So essentially, you're saying as long as you have evidence of mailing that it has been received, you've completed the service and you're good. What evidence of mailing to me is received? That's the language. Evidence of mailing is received to me is a little ambiguous. I am assuming that when we negotiated that language back in 2019, we meant that when we hand the green slip to the clerk at the post office, they stamp it received. That's what I assume it means. Before that statute, if everybody remembers, before the statute was amended in 2019, it was 10 days from receipt, and the fight you always had was, okay, what happens if the person didn't receive the letter? It was returned, then I can't go forward with it. Then we were able to clarify that, and the court said, no, we can use the mailbox rule regardless of what the statute says. So just be aware that there's a little wanky language in there, which says evidence of mailing is received. So make sure before you do your sale that you have sitting in your tenant folder a copy of the green slip that is stamped. Now, if you use a company like BDI to do the mailing, make sure that you have a tracking slip, and BDI has the ability to produce the tracking slip stamped by the post office. So it's like an insurance company, they mail stuff in batch. So they'll give them a list of 7,000 letters on a given day. The post office takes it, they run the batch, they stamp received. They're not giving them a green slip for every tiny little letter, especially if it's electronic, because most people are doing electronic now. So make sure you have that in your possession when you're before you do your sale.
Okay, good. Let's keep things moving and move on to the I'll show a few examples here. So this is an operational example of a notice of sale letter. Again, it's not intended for you to copy, but just an example of all the information that's in here, including an itemized list and details about when the auction itself, where it's being held, and when it would occur. So you should have your notice of sale letter should be something similar in this level of detail. And let's talk about advertising for the auction now. And there's a few questions that are in here. So advertising for auction. So after the demand date, you can advertise, and the law says you need to advertise. It doesn't say when, where, or how many times. So and there's different laws separate from the lien law that reference advertising auctions in the state of New York. So Joe, do you want to give us some color on this?
Sure. As Adam said, lien law 182 doesn't tell us anything about when, where, or how to auction. So what I suggest to people, well, there's really two, let me start back. There's two schools of thought. Some people are willing to advertise just once a week before the sale. I will tell you that I have had cases where that was a situation and no one challenged it and the sale was found to be fine. My general advice that I always give is if there's ambiguity in a statute, let's look to similar statutes. So in this case, I would look to what I call the sister statutes, specifically the statute that lien law 182 is based upon, which is the UCC Article 7 for the sale of a warehouse. And then you have lien law 202, which is the sale of personal property. And what they say is that you have to advertise the sale for once a week for 2 consecutive weeks. The sale can't be any sooner than 15 days from the first advertisement. If you follow, in my view, if you follow that procedure, unquestionably, you're going to be okay if somebody challenges the advertising requirement. If you follow, I'm going to advertise it once a week before the sale. I have won those. I have never had anyone challenge it, and I've had those sales be found proper by various courts. Again, it's a business decision. I recommend that you do the 2 consecutive weeks.
Okay, and this question came up in the chat in the Q&A also. Does putting the unit on the online auction site count as the required advertising? I'll answer first. I'm going to say operationally, we do not count putting it on the online auction site as advertising. For the small number of dollars for us to list it in a local paper, we put the ad there. I'll show you some examples of what those look like. We don't consider putting it on the online auction site as the advertising, satisfying the advertising component. Peter, do you have an opinion?
Well, for those of us who have smaller facilities and are not having that many auctions, what a policy that we do is we advertise twice, 2 consecutive weeks. The first advertisement that's in the newspaper, what we do is we cut out the ad, make a copy of it, and then we mail that to the tenant at the show that his storage unit has been advertised in the newspaper. Because once again, I'm trying to communicate with my tenant as much as possible, just try to get him either A, to pay what he owes, or B, vacate.
Okay.
And that might not be, it's not feasible for larger companies, who run hundreds of these auctions in a month. But if you're only running 2 or 3, auctions a month or every other month or whatever the case might be, this extra, we find it is very helpful.
Okay. And there's a question in the Q&A here. It says, so we have to wait 30 days. We send a notice of sale letter. We have a demand date, 30 days, the auction scheduled in the future. When can I start advertising? Can I start advertising within the 30 days? And how quickly, when can I start advertising?
I'm going to tie my answer. I'm going to jump in here. I'm going to tie this answer into what I'm going to sort of go back on that I didn't comment on. Adam and Peter have been very kind, and they haven't sort of put me on the spot to answer this question because they know it's a very difficult question for me to answer. But here's the thing with the online advertisements. The question asked was, does that satisfy the advertising requirement if I just advertise it online? There's a lot of companies who only advertise it online. There has been no case that answers that question. If you look at our statute, there's 0 guidance as to how you actually advertise it. So again, what I suggest when I'm stuck on these issues is I go back and I look at the sister statutes, and the sister statutes specifically reference advertising in a newspaper. And I think as long as there's a newspaper lobby out there, we're never going to get that change without an incredible fight. So here's the answer. If you want to be safe, then you better advertise that sale in a newspaper. If you want to take the position as we took, when we got the matter of Lewitton reversed, that we live in the 21st century, we need to move forward with life, then you can advertise it online and take the position that This is proper advertisement. Our statute doesn't require a particular medium that it be advertised in. If you're doing these online sales, my understanding and experience is that they will start advertising these sales on like day 15 of delinquency, and the sale will not occur till 50 or 60 days later. I'm actually okay with advertising it before the date occurs, as long as it's also advertised for 2 consecutive weeks and the sale does not occur any sooner than the 15 days. It doesn't burden me that you do it beforehand, as long as you do it during those 2 consecutive weeks afterwards. I don't love that it's done, but I'm okay with it.
Okay. I'll show some examples here. Again, the same operational example, payment was due on September 1st. This is a more conservative approach.
Adam, can I jump back in there?
Yeah.
Understand, when I say I'm okay with it, I'm not greenlighting somebody for do it, because if you read the statute specifically, you're not supposed to do it for 30 days. But if you're doing it, I can make the argument, at least validly, that it's not prohibited from doing.
Okay, fair enough. Again, back to this timeline, we're very conservative. Again, we work towards a 90-day auction process. Like, I believe you can get this to 60 days, and we're making changes to be more aggressive in that process. But we do our first legal ad about 75 days after past due. We do 2 consecutive weeks as well, which puts the second notice the week after, about 80 days past due. And then we apply what it costs us to put those ads in the paper. We apply that charge to the customer's account as well. Here's some, I just thought these would be interesting for those to see. These are some examples of some classified ads for some facilities we have in the New York area. I've highlighted those in red for the ones that specifically pertain to us. Here are just some more examples of Manhattan mini storage ads and what those look like from about a month ago. So you can see the level of detail and what's in here.
Yeah, Adam, from a legal perspective, again, we've got a limited statutes, but if you do take a look at UCC 7210 and 2021, it does say what they require, and it's actually not as cumbersome nor as and I love the advertisement. Let me start with that, but not as detailed as yours. So very quickly, when you combine 202 and 210 in, essentially the advertisement must include, meaning a minimum, a description of the property to be sold, the name of the occupant, and the time and place of the sale. That's a minimum. I mean, I actually like the Manhattan mini storage advertisement here. But those are the 3 things that at a minimum should be included in your sale.
Yeah, and there's a question here also that's sort of along the same lines. If we advertise in the newspaper, the online sale site for the auction, can we have the sale of the unit online and not in person? And I think the answer to that, if I'm interpreting this correctly, is yes. Here in these Manhattan mini storage ads, it's a newspaper ad that's advertising for an online auction. So that's exactly how we handle our online auctions. We advertise in the newspaper and then have the sale online. If I've misinterpreted the answer, then let me know.
No, I think that's, well, I believe it. I've actually said this to clients, that that's the actual way you should proceed. Your advertisement should say it's going to be sold online.
Okay. So again, did we sort of end up in a little bit, I stuck this slide in here about, our unit goes live on the auction site about 79 days past due. And again, you can do this earlier. The reason why I bring it up is because online auctions create a window where the auction is live for a period of time. In our case, it's about 10, 11 days, as opposed to historically when we had in-person auctions, it would just be on a date at a time. And it was more of a singular event. So that creates some challenges to be aware of, that's all. So there's about 79 days past due. In this example, the unit goes live for online auction. We apply an auction charge to the customer's account, and the bidding really starts at that time. So that sort of leads us into the auction the auction being complete. So let's talk about the auction, the auction ending. And I have some points here that we can walk through. Define what constitutes the sale being complete. I think it's important that the auction buyer must pay and the auction buyer has to take possession of the property. So until those things have happened, the customer could still technically, customer that was being auctioned could still technically come and pay his bill. And you should make sure that the storage operator reserves the right to cancel the sale. So I don't know if you want to add to that, Joe.
Well, the first thing I just want to point out, and you referenced it. When we did the sales at the facility, if the 15, 20, whoever showed up to bid on it, they all signed auction terms and conditions. And many of these things that Adam's talking about were all addressed in the auction terms and conditions. A sale is complete X, I can do X, Y, and Z. One of the biggest things that was always in there is you have to return any personally identifiable information to us, any guns, whatnot. On my experience with these online auction sites is they have like basically one or two actual terms of sale, which really don't cover you. So if you're doing online auctions, realize that what you used to have in a contract when they sign the auction terms and conditions are not necessarily now in place. So you have to deal with them. Again, Adam, you could probably give me a better answer to this or better advice than I can give anybody. What level do you have negotiating with these online auction sites to say, you must use my auction terms and conditions instead of the garbage 3 or 4 that you stick in there that don't really help me?
Yeah, look, we looked at online auction companies for a couple of years, and because Manhattan Mini was purchased by StorageMart, we sort of adopted their current practices. But I can tell you those terms are negotiable. You should have conversation with your auction operator. I believe there's room for conversation. There are things in the process as well. For example, this sort of third bullet point conveys what you're getting to. We didn't want the payments to be taken online because if the payment's taken online, we think there was some risk between the time payment being accepted online and if the customer showed up and the customer said, well, it's still my stuff. And because the auctioneer took the payment, does that mean the facility took the payment? Again, it's an edge case example. Maybe we're getting too technical about it, but we decided to only take the payment at the facility. So whoever wins the auction, it forces them to get down in the facility, pay us the money, and we do it in person at the facility. Again, that was something that we had negotiated with the online storage operator. So I think you should have conversation and see what's possible on those T's and C's. Another thing, the notice of sale requires to state where the sale is occurring, but online, if the sale is happening online, it's somewhere else. It's not this physical place. Do you think that poses a concern, Joe, or is it just one of those things that's subject, just sort of falls between the cracks?
You just have to put it into your lien sale letter that it's going to, you put the one line that the sale will occur on I don't want to use the name of any particular company, but on XYZ at, December 6th, 2015 at 5 o'clock. And that's when the auction will actually, the closing date is when the auction actually occurs. But as long as you put it in there, so they can go on site and they can see what's going on.
Yep, and these last 2 bullets are just, I just wanted to remind people if the auction, let's say they owe $1,000 for the unit, Joe, and it sells at auction for $1,500. Can I keep all that money? What do I have to do with the excess proceeds from that auction?
You have to return whatever you get above the amount that's owed. So it's a simple letter. I mean, we all have the post lien sale letters that you send out. If there's $500 due them, send them the $500. Question I think you're going to ask me is what happens when it comes back, can't be delivered. There's a whole process in place. I mean, worst comes to worst, eventually you can turn the excess proceeds over to the state and they just put it into this, I'm being very short with the description, but they put it into basically a holding tank for a year and then, they can make the claim to the excess proceeds through the state.
Right, and I just bring that up to remind people, this achievement process is sort of the more technical name for it that the state manages. So if those funds are returned, they're undeliverable, then you should enter that achievement process with the state of New York. Okay. So some other auction related questions. What happens if the contents of the unit do not sell at the auction? I can just throw all that stuff out, right, Joe?
Not in my opinion. Okay, and this is where we get down to the nitty gritty of our statute. Unlike a lot of states, so I'll use Michigan because I did a quick search yesterday, Michigan or Connecticut, there's or otherwise languages or otherwise disposed of or similar language to that. In, for instance, Connecticut, that means I just throw it out and they will literally just throw the property out. There's no auction in Connecticut in many instances. In Michigan, they can do the same thing. New York does not have that language. So in my view, if your unit does not sell, you cannot simply throw the property out because there's no right to simply throw it out. So if you don't have that language and you haven't done what I'm going to suggest you do beforehand, you have to resell it. Now, I understand people don't like that. I've had clients tell me they disagree with me. So I usually say, okay, do what you want to do, but this is what I'm giving you the advice on. What I suggest to everybody is that simply do like the banks do when they're selling real estate at a foreclosure sale. Set the base bid in $10, bid in $5, bid in $15. So if it doesn't sell, or if nobody outbids you, you now own it and you do whatever you want with it. As long as you're not getting into a bidding war with somebody, you're perfectly fine. If you start getting into a bidding war with somebody, you got a real problem because you've seen what's in the unit before the sale occurs. And God knows the general business law violations that you're going to get hit with. But I recommend to everybody, make a bid. Now, I'm sure someone's going to say, I do 6,000 lien sales on a given day across the United States. Am I supposed to bid on every one of them? Make a business decision. If you're bidding $5 in on every one of them and you're protecting yourselves, that's great. If you can't afford to do it, don't do it. If you're selling 3 units a month, then I suggest you do it without even thinking about it, because the agony you're going to save yourself of redoing an entire sale is worth it. Or the risk you take of somebody bankrupts your company because they come in and say you didn't have the right to do that, and your lease didn't have the proper provisions to limit the recovery. You got a problem. It's a business. It's largely a business decision, but it's a very, very simple fix to making life real simple. And I'd love to hear Adam and then Peter, your view on that.
Well, we buy the units if we find the auction's ended and nobody's bought it and there's stuff in the unit, we buy it for what we call non-commercial value. So I forget the exact amount, $15 or $25, but we'll put a bid in and we'll buy the unit. And then at that point, the auction closes and we will then dispose of the items that way. We're down to just a couple, we're just down to the last couple minutes. So we're going to try to answer these like rapid fire. I know, we won't be able to get into the detail. There's a couple questions I want to get to throw out to the panelists. If I open a unit and I find a bunch of PII, personal and identifiable information, should I continue to sell that unit or should I not?
Well, from a legal perspective, you can't sell the unit that has personally identifiable information. So if you have the auction terms and conditions, which say that things with personally identifiable information, birth certificates, things like that nature are not part of the sale, and you don't know they're in there, then it's the obligation of the person who purchased it to give it back to you. If you open the unit and there's nothing in there, again, absolutely nothing but personally identifiable information, unless you want a situation like Maine, 15 years ago and have your unit, you basically have your operation shut down for a month, just don't sell the unit. It's a nightmare scenario. You got to get in touch with the person. You got to tell them, just take your property and go. You got to build enough of a record. And when it gets to the point, you make a business decision as to what you're going to do with that property. Again, it's purely a business decision because you can't just throw it out. You have to take a bajillion steps before you say, I need to protect this person's, the identity of these individuals, and then shred it. Again, you're making a pure business decision at that point.
Yeah. Okay. I'm going to move on to other special cases I think you should be aware of. If you encounter these things, get some legal help. If you get a notice that there's a restraining notice on the unit, you can't sell it, get some legal help. If it involves a decedent, the tenant has died, get some help. If it's a bankruptcy case, these can get really complicated, get some legal help. But there may be third-party claims, and you should also, if they've identified themselves as military, some people do military checks before they auction the unit. So that's another step that you can take. But in these situations, get some help. They're special cases. We're not going to cover them today. We can probably do a webinar on each of these things by themselves. And storing boats and cars, this came up in the Q&A, is a completely different process. It does not fall under lien law. So that's a different part of the process. You should not use the lien law guidance to get rid of boats and cars.
Well, just one difference to that, Adam. I agree with you. Storing, if the car is inside the unit, you can sell it at a lien law 182 sale. If the car is if you're using your property like a parking lot, and I'm not talking about you're storing something, you're saying this is just an extension of my storage facility. If you're using it as a parking lot, that's not, and I will stick with this till I die. That is not a lien law 182 scenario. If you're going to be a parking lot, act like a parking lot. There's a different statute for that.
Okay, I'll just hit a couple questions. If you open the unit and you see there's a bunch of photographs, do photographs count as PII?
Technically, no, but you shouldn't sell the photographs. In all my auction terms and conditions, photographs are carved out. They have to be returned.
Okay.
I mean, there's a definition for personally identifiable information in the law. So no, the answer is no, technically, but I would tell you, pull them out.
When you do the advertising in the paper, should you put the tenant's name in the paper? Should
Yes.
that be- Okay.
Yes.
And
How else is the person, I mean, just honestly, how else is the person going to know it's their unit?
let me see what else is in here. Regarding abandoned units, this will be the last question, then we'll wrap up. Regarding abandoned units, if I open the unit during lock cut and it has like a few trash bags on the floor and just a few paper, like if there's minimal contents, the question is, you know, is there a legal definition of if the unit's been abandoned, like empty? If it has a few little things in it, should I proceed with the auction because they left like a trash bag in there?
There's no legal definition of what constitutes an, you know, when I open it up, it looks like it's abandoned. I mean, the only legal definition you can get is a person comes to you and says, I don't want it, I abandon it. And then you have them sign an abandonment form. These are all tough decisions. I've had cases where people we've deemed it abandoned, thrown it out, and the guy sues us for it. And it turns out the guy had a Rolex watch sitting in one of those bags. It's really a judgment decision. If in doubt, go forward with the sale. But I mean, it's pretty obvious when something is deemed is abandoned. I mean, there's like the scenario you just gave, Adam. There's a garbage bag of garbage sitting in the, obviously it's abandoned. I mean, look at the garbage bag, make sure it's not a box of Rolex watches in there. But if you open it up and it's used, you know, I don't know, tissue paper, then yeah, it's abandoned.
Okay, and just the final reminder, just like Peter said, you know, auction's the last resort. There's a number of remediations that you can do before auction. You know, obviously you try and make phone calls for full payment, partial payment. You can try and get that tenant to downsize units. You can do a termination agreement, which is where they don't pay any money and they just agree to leave, or maybe they give you some partial payment and they just agree to leave. You can do abandonment agreement where they just leave everything and you just take care of it just to get rid of them. And I'll tell you, we've even done cases where we've paid the tenant money. And I know this sounds extreme. Somebody were like, you're crazy, but we're like, here, we will give you $100, come and take your stuff. Sometimes that's the incentive because the real goal here is just to get the unit back. So we have taken that step before. Go ahead, Joe. Did you want to add on?
No, I'm just looking at one of these questions, which is actually a really interesting question, but I don't want to usurp my power. But do you see the one from anonymous attendee at 1:31 p.m.? That's actually a really good question.
Yeah, so we recently purchased a facility that was at full capacity. We moved the facility to third-party management and online services. New and old tenants created accounts and have signed our new lease agreement through their online accounts. Great. However, we have a few tenants who are multiple months late and have not signed our new lease agreement. Can we go ahead through the lien auction process based on our, I assume, new lease agreement, or do we have to follow the lease agreement that they signed with the previous owner? What should they do?
Okay, this is the first question, whether your attorney who did the closing had his druthers. Any attorney who sells a existing self-storage facility is going to have a major assignment of all leases from the owner of the leases to the person who's now buying the facility. So if that's occurred, then you now have all the rights of that previous owner, the previous owner of the facility. So you can move, assuming, obviously you don't have a lease, which is a nightmare. Assuming that there's a written lease, then you can move forward with the sale. Now, I have a client who's extremely good at this. They send out notices which basically say, if you do not sign the new lease, and obviously we got to have the 30-day requirement in there. If you don't sign one of our new leases, we're going to deem you to have signed it, and it follows the whole procedure. That's another way of doing it. It's you have to be very careful in the way you do it to make sure that your previous lease allows you to change all the terms and conditions upon 30 days notice.
So it gets complicated. So like we said in the beginning, get some legal help in those situations. That's a very good question. So there are a number of other questions we just weren't able to get to at time, but we'll go through, and if you have your name there, I'll reach out to you. Otherwise, send your questions in through the NYSSA website, and Peter and myself are on the board. We'll get in touch with you and give you some direction how you can move forward on getting answers to some of these questions. Eric, do you want to wrap this up for us?
Sure. Thanks, Adam. Thanks, Joe and Peter, for your participation. And thank you for everyone who attended today's webinar. Recording will be posted on the NYSSA website this week. If you are not already a member, please consider joining our association. We have an active board that works with the lobbyists in Albany to ensure that self-storage has a voice in New York State. We also offer operational guidance to our members. Visit our website, nyselfstorage.org, or send us an email, admin@nyselfstorage.org, for more information. And don't forget to join us October 3rd and 4th for the New York Self-Storage Association Annual Fall Conference in Tarrytown. For more information, please visit our website. Thanks again to our corporate supporters, Extra Space, Life Storage, Public Storage, and Storage Mart. This concludes today's program. Thank you for spending your time with us. Thank you,
Thank you, everyone. Thank you,
Thanks,
Peter.
guys.
Thank you, John.
Thank you.
Take care.